Welcome back to another episode of Dreading, or if this is your first time here, welcome. Today, we're going to be reviewing Sarah Boone's time on the stand, as she was surprisingly called to take the stand during a suppression hearing. This is highly irregular, as the point of the hearing is for her counsel to argue against evidence being brought into trial, something that she has no say in or relevant information to present. Her input wasn't necessary, as she provided absolutely nothing to help the defense's argument. But, as Sarah has shown time and time again, if she wants to do something, even if it's antithetical towards her own freedom, she will do it. One thing we have noted in all of our coverage of Sarah is that she believes that she is the smartest person in any room and the most well-equipped to defend herself. She operates under the belief that the majority of people would side with her if they listen to her speak, and anyone who doesn't immediately submit to her way of thinking is, of course, against her implicitly, and probably part of a grand conspiracy to put her in prison, even though she has never done anything wrong in her life. This, of course, is a grand delusion, which has no basis in reality or fact. Even if this had been true prior to her arrest, she's been in jail for 4 years now. But her insistence that she be called to the stand by her lawyer during this hearing has hurt her chances at freedom, because she would go on to state something that would go against the battered spouse defense that they're planning to use. We didn't anticipate Sarah taking the stand at this hearing, and had planned to release another video this week. However, given our continued coverage of the case, and the fact that it has become somewhat of a special interest of mine, we decided to push back the other upload for a week. That video is now live on our Patreon though, along with another upload that was meant for 2 weeks from now. But with all of that said, let us begin. Before we get into her time on the stand, I want to clarify that Sarah's lawyer is not incompetent. He is not attempting to throw the case so that it could be tried later. He is genuinely working extremely hard to argue a winning case for Sarah, as is her right. One thing to also remember is that he was just hired. He has hardly any time to prepare, and the judge is dead set on getting this case to trial as soon as possible, because her antics have wasted years. So any comments about how poorly he is arguing should be pushed aside in that regard. No lawyer purposely does a bad job in court, and he is working under very strange circumstances. Even the most effective lawyer would have a hard time dealing with Sarah, as we have seen time and time again, and again. His client also refuses to let him do his job in a functional way, still believing that she knows better than him. Most of the decisions that are being made in this case are being made by Sarah, as she refuses to listen to his expert opinion. Sarah is in the driver's seat, unfortunately, and her lawyer is simply the avatar that she needs to put forward to promulgate her point of view. This particular hearing is meant to discuss whether the interrogation footage from the day after the murder can be brought into trial. Sarah's attorney is arguing that she was coerced into talking to the police, as they asked her to come to the station to retrieve her cell phone, when they really intended to question her about the video they found. He contends that because Sarah was tricked, she was made to feel as if she didn't have the right to leave the interrogation, and that everything she said after the fact was said under duress. This is important because if they're going forward with the battered spouse defense, Sarah's insistence that the death was an accident and not intentional in that interview goes against that argument. They need to prove that at the time of the murder, Sarah felt that her life was in danger and that the only way she could escape George's abuse was to kill him. That argument is going to be difficult to prove, knowing the facts of the case, but it's the best defense that she has, given her history with George. They want to make their case as robust as possible, and frankly, eliminating the interrogation is a good way to go about that. Sarah's behavior and general antics after the murder are obviously shocking, which is why so many channels like my own have covered her, with some channels focusing on her exclusively. Their main support for their motion to suppress is that the lead investigator failed to ask Sarah the last question on the Miranda rights card, that being, having these rights in mind, do you wish to talk to us now? However, after the other 8 rights were read out to Sarah, and she signed a document with that question present, granting her consent, the argument isn't as foolproof as one might hope in these circumstances. In fact, when Sarah arrived at the police station to pick up her phone, she brought along a list of questions for the police, which you can infer means that she had no issue talking to them. Furthermore, their argument relies on the idea that Sarah was treated poorly by the police and was meant to feel that she had to speak to them. As we have covered on this channel, there are absolutely cases of coercion, where the police bully, badger, and abuse a suspect until they get the information that they want. In those cases, though, there tends to be an obvious red flag, like a security camera or a body camera that's been turned off, or tape recorders not being turned on during the full interrogation, or a history of gaining false reports by the interrogator. None of those issues are present in this case. In fact, the opposite is true. We've seen the body cam footage from the morning of, and we've watched the security footage from the police department in the interrogation. At no point did the officers engage Sarah in a cruel or commanding way. If you rewatch any of the videos going over Sarah's behavior from that morning, they treated her outstandingly well, making her feel as if she was a victim until they showed her the video of her mocking George as he was dying. So the idea that the police were confrontational or at all forceful with her falls entirely flat, in our opinion at least. There is also notably no case law that bolsters the argument presented, as the other 8 Miranda rights were properly asked, and Sarah signed a document with the 9th present. While this is by no means a strong argument, it's her lawyer's job to argue it as it gives her the best chance of success. While Sarah likely did not think of this herself, it's probable that when her lawyer told her that he was going to try and exclude the interrogation based on her feeling coerced, she demanded to go on the stand. In her mind, her input was vital to the case, especially since they were talking about her feelings. But the opposite is true. Sarah taking the stand to discuss this motion is nonsensical, because nothing she has to say can possibly improve her lawyer's argument. He needs to be allowed to present the case in the most effective way possible, by presenting case law, going over the pertinent facts, and creating an appealing argument, and Sarah's inclusion gets in the way of that. Her taking the stand to talk about how she feels is irrelevant. You can feel like you were lied to, that the police weren't being fair towards you, but that doesn't change the facts of the matter. But this is Sarah we're talking about. Facts have never truly affected her as far as we have witnessed, because she simply doesn't care about them as long as they don't align with her worldview. Remember, she described herself as an attentive, supportive wife and mother, despite her leaving her child in order to go out drinking in the middle of the day. But her lawyer can't comfortably tell Sarah no without having a fight on his hands. Most other establishments talking about this case discuss how he is likely choosing his battles with his client, trying to get her to do what's best for herself, but ultimately allowing her to make decisions that will hurt the case. And this is no doubt one of those occasions. Prior to Sarah taking the stand, her defense had a chance to question the lead investigator about why the last question was not said, and argue that Sarah had been coerced. They were able to make a few points, but the judge appeared unmoved by their assertions. That officer has just left the stand, and at this point, the judge believes that they would be moving on from that specific motion. So let's watch.
Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Ms. Boone can approach the podium. She was previously sworn at the beginning.
Judge, I'll be here.
Yes, sir. Hang on, the deputy's got to move her.
There are some obvious microphone issues, specifically with Sarah's mic. The audio is going to be a bit grating to listen to, but I've tried to remedy it and there's not a whole lot I can really do to repair it, so my apologies. So I've spent a fair few minutes talking about why Sarah taking the stand is a bad idea. We all understand that this is not going to go very well for her, but she is completely unaware of that fact. As a matter of fact, based on her body language and facial reactions, you would think that she's about to testify against someone else who had harmed her. She seems irrationally confident, as if she is in the right, and that what she says is more important than the prosecution, judge, or even her own lawyer has to say. It's this sort of delusion that makes Sarah so interesting to us. She has all the confidence in the world, with none of the achievements to back it up. Moreover, this unyielding faith in herself has never served her, not in this court case, not in the case against her ex-husband, and certainly not in her life prior to killing George. In fact, it's the reason why she continues to make so many obvious, careless mistakes. She is so confident that she can't fail, that what she is saying is good and right, that she ruins every potential argument that she has.
Ma'am, you've already been sworn. Counselor, you may proceed.
Ma'am, would you please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
I was very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
All right, and she has just fucked up her own argument. Just truly fucked it right up. As mentioned, Sarah is going for the battered spouse defense, which infers that the defendant in question perceived that their life was in danger at the time of the murder, and the prosecution will inevitably argue that if she was drunk, her perception cannot be trusted. In other words, how could she perceive a threat if her perception was impaired? But more importantly, they want to get the interview suppressed because what she claimed in it completely goes against their defense. She said repeatedly, to the point to where it's now a meme, that what happened with George was unintentional and an accident. She didn't mean for him to die. She simply went to sleep and thought he would have gotten out of the suitcase by himself. This flies in the face of their defense, because how could you feel reasonable fear for one's life when you were drunk and he was in a suitcase? This also discredits her earlier statements given at the crime scene with the responding officers, and in her police interview the following day, because on both occasions she claimed that she was not drunk when the incident occurred. She said that George and her shared some wine. Then they did a puzzle and then decided to play hide and seek, but she didn't black out because she wasn't drunk. Now we can obviously see that that isn't true. She was clearly hungover, and most of the statements she's given about her life are just lies. The channel Melly D has uploads of the police interviews with Sarah's ex-husband, as well as Sarah's landlord and neighbors that all demonstrate that Sarah wasn't drunk, with little regard for the people around her, and could not go a day without drinking. But in the interrogation, she claimed otherwise. Should the footage be allowed at trial, the prosecution can now prove that she will lie and say whatever she thinks will get her out of trouble. In addition, she talked about her mental state at the crime scene, whereas the interrogation that they are trying to suppress happened the very next day. Her lying the day of might make sense if she was drunk. Is she trying to say she was hungover then as well? Is she claiming that she went into the police station to talk to the cops completely plastered? It's irrelevant information that discredits her statements, and if the interview isn't suppressed, it will demonstrate to the jury that she cannot be trusted. Before we continue, the prosecution is about to object due to relevance, which you might believe is counterintuitive to their case. Obviously, allowing her to stay on the stand and say whatever wacky thing she believes will get her out of jail the quickest would be interesting, but this isn't trial. This isn't in front of a jury. This is simply a motions hearing.
Objection, Judge. Move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the
Are
day
you-
before the interrogation.
I understand that.
We're not talking about an intoxication.
But are you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the three motions that have been filed.
Judge, I didn't ask her that. She volunteered that.
I understand it.
Okay.
Objection sustained, and it's stricken.
So the judge also agrees that what she is saying is irrelevant to the motions that they are discussing, which is obviously not great for what the defense is trying to argue. Her lawyer throws in that she is offering information he didn't necessarily ask for, which feels more or less like a way to endear himself to the judge a bit, but Sarah has no idea that she's already heard the case. Watching her reaction during the back and forth between the lawyers and the judge is interesting, because you would think that she would feel strongly that what she is saying is relevant and want to keep it in, or she would understand that what she just did is being argued because she said something wrong. Instead, she just sits there, seeming a bit annoyed that she isn't being asked anything. It's kind of like she's waiting for a coffee order and she's a little frustrated that it's taking too long. It's small things like this that make her so interesting to watch. She has the same ego as someone like Tony Todd, but her reactions are a bit more subdued.
Did you speak to the deputy about what had happened?
Yes.
Okay. And then, were you asked to stay on scene?
By both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? What, was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesell asked me was if I owned a phone.
In our video going over Sarah's letters to the court, we commented on the fact that she had a tendency to overuse words in order to try and seem intelligent. Instead of saying, "I feel like I'm being unfairly penalized," she would say, "It is my subjective understanding of the facts within this case that I am being left behind by the justice system that happens to be currently established in the United States of America, and, of course, gubernatorially by you, Honorable Judge." And she does that here as well. It's important to her that she comes across as intelligent, so that everyone in the courtroom knows that she should be respected. She even stated in a past letter that she isn't like other inmates and defendants. She's of a different caliber and should be treated as such. It will be interesting to see her do this at trial, when she takes the stand in her own defense. This just feels like a foreshadowing of what's to come.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hopesell.
How did you unlock it?
She handed it to me, and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you were spoken to by Detective Copesel was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
Police don't need to tell a suspect that they are a suspect before talking to them. While this should go without saying, unfortunately, it doesn't. That doesn't mean that Sarah was coerced, or that the police did anything wrong in this specific case. It also bears mentioning that it should have gone without question that Sarah was a suspect in this case. She was the only one with George when he died. The circumstances of his death were extremely questionable, and she never attempted to resuscitate him, according to responding EMTs. Logic should have told her that she was a suspect, even if the police did not. But logic and basic reasoning are not her strong suit. At trial, I think it'll be likely that her lawyer is going to argue that the police should have informed her that she was a suspect before talking, both at the scene and at the police station. But that is more for the jury's benefit than anything. This is a tactic that defense attorneys often take to try and show that their client was unfairly treated by law enforcement, and usually it's just one of the avenues they go down. They tend to have supplementary evidence that can showcase how their client was treated unfairly, or at least present reasonable doubt. But as we stated earlier in this video, the police handled this case extremely well. No body cams were turned off, she was never spoken to outside the presence of a recording device, and it's so heavily documented that if she was to assert that she was treated poorly, the jury can simply watch the tapes and see that that isn't true, which would only supplement the prosecution's argument that Sarah is a liar who will say and do anything to get away with murder.
Did he ever refer to the videos that you recorded on your phone from the night before? Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes,
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes,
And at some point, did they tell you they were finished with the work there at the scene?
yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Copesel?
I did.
And whose phone did you use?
Former husband, Boone.
You said your phone had been seized,
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Copesel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Copesel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her.
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her, in all honesty, that I felt that she was trying to trick me.
Objection. You're relevant.
Sustained.
Despite the objection being sustained and Sarah not finishing her thought, it was obvious that she was going to say that she called the officer to say that she felt uneasy and thought they were trying to trip her up, and pin the blame for George's death on her, which is a very interesting thing to think, when she was objectively responsible for what happened. George may have gotten into the suitcase willingly, but she is the one who zipped it up, obstructing his ability to breathe and leading to his death. She also recorded him suffering, openly stating that he was dying, and did nothing to render aid. While Florida state law does state that there is no duty to save someone's life or otherwise assist in the event of an emergency, there are obvious exemptions to this, like if you created the danger yourself, so she was obligated to assist George, meaning legally she is at fault.
Did you have a conversation about your phone?
Yes. I asked her.
Answered.
Overruled. You may answer the question, ma'am.
I didn't call for a yes or no. She said yes, and now I don't know what's pending and how to object.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant, and asked me if I remembered about when I was being pregnant, and it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Kopsel was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car, and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like for you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay.
By emphasizing the firearm in this line of questioning, her defense has made it clear that they intend to argue that she was somewhat in fear for her life, that a gun being on the officer's person during the interrogation was done intentionally to make her feel as if she could not leave, and that she was in immediate danger. Again, there are cases where a suspect's life is threatened, where they are being treated heinously by the police, and they are repeatedly told that they cannot leave the interview room without giving the interrogator exactly what they want. The one that comes most readily to mind that we've covered is the Norfolk 4, where the lead interrogator repeatedly threatened each one of the men's lives until they confessed. But this is nowhere near the same situation. Neither detective withdrew their weapon. At no point was she threatened, and any conversation with the presence of law enforcement likely occurred with guns actively present. So while we understand why this would be used to try and bolster their argument, it's a fairly weak point.
So y'all got off the elevator? Where did you go from there?
He brought me into a very small room, and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
This also destroys her argument so completely that I don't know why she would say it during this hearing. Again, their goal is to get the second interview suppressed because she was coerced. They argue that she was tricked into going into the station because she needed to pick up her phone and didn't intend to talk to the police. So when she was placed in an interrogation room, she was made to feel as if she could not leave. But her bringing a list of questions that she had for the police about the case negates that entirely. She obviously wanted to speak with them, to have some kind of back and forth, and she consented, both verbally as well as with the document that she willingly signed.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else
No.
prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator and walked into the interrogation room.
Correct.
And then we've got the video on that. Now, you and I have watched the video,
Yes.
correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
Yes.
You recall that happening.
Yes.
Did that refresh your memory watching the video?
Yes.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
Yes.
This was prior to you being read your Miranda rights.
Correct.
And she also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we just have to do it.
Yes.
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way.
Were you trying to cooperate?
In every way.
Were you polite with them?
Very.
And when she said that, we just have to do it, you said, just like we did yesterday.
Yes.
And then you said normal protocol.
Yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes.
Had she said the same word? You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
Okay, so while we understand why this is being asked and repeated, it's such a poor argument that it feels stupid to harp on this point. She was never asked that, but she did sign a paper where it was asked. And she also came into the station with the intention of talking to the police herself. Her list of questions makes that obvious, so the implication that she wouldn't have given her consent to speak to the police had they asked her that last question falls completely flat.
The way that she acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Objection, irrelevant. She's in custody.
Sustained.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
Okay, but she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space.
That all goes to whether or not...
She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her Her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation.
Okay.
I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not,
What's the subjectivity matter?
Excuse me, based on
Subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection's sustained. I apologize.
Did you understand you were not going to get your phone back until you answered their questions?
Objection relevant.
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Objection relevant.
Sustained.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes,
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Yes.
Objection relevant.
Overruled.
Were you there answering the questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
Yes, sir.
So Sarah's about to be cross-examined, which again is not normal in a motions hearing. The state has no time to prepare, but Sarah's previous statements have left a lot that they can work with, and it's extremely telling where they immediately go with their questions. But before we get into their short examination of Sarah, let's address what the defense attempted to establish. At the time of recording, it's unknown whether or not they were successful, but based on the judge's reaction, I would venture to say they won't be. They're arguing that based on the totality of circumstances that occurred in this case, prior to Sarah being questioned the day after George's death, that the interview itself was coercive and should be suppressed. In order to supplement this argument, she claimed that the morning of the event, she was intoxicated at the scene, that when the interview took place the next day, she had been lied to in order to speak with the police, that the lead investigator didn't read out her full Miranda rights, and that the other detective present during the interview had his weapon visible. The first issue in this argument is that while Sarah was drunk at the scene, that has no effect on how she would have perceived an interview the following day. If you were drunk yesterday and I talked to you today, your perception should not be impaired. Moreover, it's not illegal for the police to lie about the reason about why they want a suspect to come in for questioning, though defense attorneys will bring up these lies in court as a way to plant the seed that their clients were being railroaded or that the police in these cases are being dishonest. It's not legally wrong. Additionally, despite the last Miranda rights question not being read out, Sarah did sign a document where it was present. Her lawyer knows that this is a weak argument and that the interview will likely not be suppressed, but it's his obligation to argue it. He needs to provide Sarah the most effective defense possible, so that we can say justice has really been done in this case.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Earlier, when Sarah claimed that she was still drunk when the cops arrived at her apartment, the prosecution objected due to relevance. However, it's the first thing that he brings up when he gets to question her, and that's because he is attempting to lock in that what occurred in this case was an accident, that she killed George while he was blackout drunk, that her recollection of events cannot be trusted, so her assertion that she was in fear for her life was false, and that the battered spouse defense does not apply in this case. He's dismantling her own statements, as well as showing that her own perception of events cannot be trusted in this case. This is why her taking the stand at this hearing was such a monumentally bad decision. She has given the prosecution so much more to work with, simply by opening her mouth. We've said this time and time again while reviewing this case, as well as her correspondence with the court, but her refusal to allow her lawyers to simply do their job only makes things worse for her. She has this outstanding belief in herself that borders on delusion, because we have never seen her win an argument or make things better for herself, and yet she still contends that she is a genius, that she is the only person in the world whose opinion matters in this case.
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? And you consumed no alcohol in your home that morning, correct?
Correct.
So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
This goes to discredit her perception of events and how she was made to feel. Earlier, she claimed that after the initial conversation that she had with the lead investigator, she felt uneasy about what had happened, like they were trying to unfairly pin the blame for George's death on her and trip her up, so to speak. But if she were drunk at the time of the conversation or hungover, how can she confidently say that her feelings were because the detective did anything wrong?
Now or then?
Then.
Did alcohol affect my conversation with her?
There's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect? My answer?
Judge, I don't think she understands the question.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she didn't know what. She said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she had said she didn't know what.
What are the legal grounds of your objection?
I'll withdraw.
All right, you may proceed.
All right. And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct?
I understand.
Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Regarding the...
I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copesel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all of the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail, meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted.
Of course.
That last segment was a lot, so let's break it down. The prosecution is essentially arguing that Sarah had an absurd bias in this case, based solely on the fact that her future hangs in the balance. With that in mind, she has the motive to lie and change her story based upon what she thinks will lead to her release. And they are arguing that the continued shifting of her statements showcases that. I will leave a link in the description box down below to the remainder of the footage from this hearing, but as Sarah's time on the stand has come to an end, we will leave it there. Let us know what you thought of her testimony here. Do you think she helped her case? Why or why not? And let us know if you think her counsel will be able to successfully argue the battered spouse defense. I'll be watching this trial live, likely on Law and Crime or Court TV, so we hope to see you there as well. Goodbye. Oh no, the video's coming to an end.